Hello, everybody, and welcome. Today I want to ask you a question. What is the first question to ask a doctor during his pretrial question and answer session known as a deposition? You want to know what this is about? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now, let's say you've decided to bring a lawsuit, a civil lawsuit, seeking money as a form of compensation against the doctor who caused you harm. You've now determined that you have a valid basis for a case. And in case you don't know that here in New York, before you are able to proceed forward with a case, you have to get confirmation from a medical expert that, number one, there was wrongdoing or carelessness. Number two, that the wrongdoing was a cause of your injury. And number three, that your injury is significant or permanent. So now, once you've gotten a medical expert to confirm that you have a valid basis for a case, guess what? You can actually go ahead and get your case started. But now, during the course of your lawsuit, there's a process known as discovery. And that's a period of time where each side has an opportunity to learn information from the other side. You see, the defense attorneys don't know yet all the details about what happened to you. They don't know what you think was done wrong. They don't know how your injuries have affected you. So what they need to do is they need to accumulate and gather all of your medical records and all of any other records that we have available for them. Likewise, we need to do something similar. We need to obtain medical records from your doctors. We need to get medical records from the hospitals where you were treated. Why? Because this way it will help confirm exactly what our claims are. So now, in addition to obtaining medical records, we also have an opportunity to question the people who are involved in your particular case. That's known legally as a deposition. Now, the defense attorneys will have an opportunity to question you during the course of this discovery process. And now that takes place in your attorney's office. And there's no judge present, there's no jury present, but there is a court reporter to take down and record all of the questions that you are being asked and all of the answers that you give. And by the way, you should know something really important. That question and answer session forms the basis of your pretrial testimony. And also you should know, this testimony carries the same exact weight as if you are testifying at the time of trial. A lot of people don't know that. So you think, hey, just because you're in an attorney's office and it's an informal setting, you can say anything you want. Well, that's not true, because everything you say can and will be used against you by the defense when your case goes to trial a few years down the road. So keep in mind that this is, in fact, the same as if you are testifying at the time of trial. Hang on one second. Let me grab some water. So the defense gets their first shot at you by asking questions. A couple of months later, we have an opportunity to ask the doctors who you have sued and any other staff or hospital staff that we need to be able to question them during their pretrial question and answer session, also known as a deposition. You should know that we also use a term called an examination before trial, which says the same exact thing. So now, you will find that when an attorney questions a doctor during his pretrial question and answer session, most attorneys are taught to start off their questioning by asking the doctor a series of questions about his credentials. Hey, doctor, where did you go to college? Where did you go to medical school? Where did you do your internship and residency training? Are you board certified? Are you licensed to practice medicine in the state of New York? Those are the same basic questions that every attorney walking into a doctor's deposition should know before ever questioning the doctor. These are basic, dry questions, and we have that information. We know it. So why do attorneys continue to ask the same dry, boring questions at the beginning of every question and answer session of every single doctor? You know what I say? That's garbage. That's nonsense. Instead, there's a much better way to do it. There's a much better strategy to go after the doctor at the very beginning. And it has nothing to do with asking the doctor about his credentials. I know his credentials. He knows his credentials. I'm going to get his CV explaining it. And later on during my question and answer session, I certainly will ask the doctor these questions. But I typically save that for the very end. That I save for the end. Instead, I want to ask the doctor the most important question at the very beginning, as soon as I start. And also you'll find that some attorneys like to turn around and tell the doctor, give him a whole long preamble Now, a preamble is a set of instructions. And here's what a lot of attorneys do. Doctor, I'm going to be asking you a series of questions. If you know the answer, please tell me the answer verbally. If you don't know the answer, then tell me you don't know the answer. Don't guess. Really? Do you have to say that? No, you don't have to say that. Also, some attorneys will turn around and say, Doctor, I want you to understand that you cannot turn to your attorney to ask him a question in the middle of while I am asking you a question. You have to answer my question first, and then you go ahead and answer. And if you need to speak to your attorney afterwards, you can go out in the hallway afterwards. Okay? That's what some attorneys do as part of their instructions to the doctor before they start their question and answer session. And again, you know what I say to that? I say that's total bull. It's a waste of time. It's obnoxious. Just get to the heart of the case. Right there. Very first question. Doctor, why did you operate on the wrong side of the brain? And the defense attorney yells out, objection! You can't do that. There's no foundation. And gives a whole host of other legal objections that he can think of. Why would he do that? Why would the defense attorney object to wanting to know immediately whether or not he operated on the right side of the brain? I'll tell you why. Number one, because the attorney is not prepared for such a question. Number two, the doctor is not prepared for such a question. It's what we call, it's a pattern interrupt from psychological terms. Okay, it's not something that he was expecting, and therefore he's now off track. You see, before the doctor is ever questioned by the plaintiff's attorney, the injured patient's attorney, he will have been prepared by his defense lawyer. And when I say prepared, I don't mean that the attorney is putting words into his mouth. I mean that he's going to go ahead and refresh his memory about the events that occurred. They're going to go through the medical records about what actually occurred to you. And then they are going to go through hypothetical questions that I or another attorney might ask them, so that now the doctor feels comfortable asking those types of questions. So, in my opinion, my best suggestion is to go ahead and ask the most critical question in the entire case first. So if it involves a case where the doctor operated on the wrong side of the brain, my first question will be, I don't give this whole preamble bull. I don't say, doctor, I want you to do, his attorney has given him instructions on what to do and what not to do. I don't need to repeat that. Instead, I want to go right to the heart of the case as my very first question. Good morning, doctor. Why did you operate on the wrong side of my client's brain? Objection! Objection! You can't do that. If I get that kind of objection, you know what I say? I say, counselor, can you show me where in the civil practice law and rules, CPLR, the civil practice that says I'm not permitted to ask the critical question as my very first question during this pretrial litigation process? And he can't give me an answer because there is no rule that says that. Then he will say, but you haven't laid a foundation. Now, what does that mean, that I haven't laid a foundation? I'll tell you what that means. Typically, if we are at trial, I want to set the scene for what the doctor is going to be answering questions about. So I might turn around and say, doctor, I want you to assume that Mrs. Jones came to your office on January 1st. On that day, she made the following complaints. And I want you also to assume that she filled out a patient information sheet with all of that information. Now, based upon that information, and now that lays the foundation. It sets the scene for what happened and what I'm about to ask. Now, the attorney has raised an objection that says, counselor, no foundation, I object. Now, I can do one of two things. I can argue with him about whether or not his client, his doctor, has to answer the question the way I asked. And to me, that's a waste of time. Instead, I can ask the same question 10, 15, 20 different ways. So now if he says that there's no foundation, rather than arguing with the attorney, which so many lawyers do, I'm going to turn around and say, okay, doctor, isn't it true that you operated on my client on January 1st? Yes. Isn't it true that your intention was to operate on the right side of the brain? Yes. In fact, that's what the discussion was with her before she agreed to have surgery. Isn't that true? Yes. And it was your intention as you were going into the operating room to perform surgery on the right side of her brain. Isn't that true? Yes. Doctor, explain to me how it was that you operated on the left side of her brain. Now, what does he say to that? He doesn't say anything. You know why? Because now I've set the foundation. I've set the scene. I've now described exactly the parameters upon which I'm going to be asking him this key question. And in just the span of 30 seconds, I created that foundation. And now the doctor has to answer my question. And that sets the stage for the rest of the entire deposition. Why? Because now the doctor doesn't know where I'm going to be asking my next question from. What's it going to involve? Doctor, I want you to assume the following things were done, or the following thing, the patient complained of the following problems. Assuming those things to be true, which is based upon the facts that we have established already during this case, assuming that to be true, would you agree that it would be a violation from the basic standards of medical care not to do A or B or C? The doctor has to answer those questions as well. So let's go back to the original question that I asked at the beginning, right? What is the very first question that I like to ask during a doctor's pretrial question and answer session known as a deposition? And the answer is, I like to get to the very heart of the case with my very first question. And if by some chance the defense attorney yells out, "Objection, there's no foundation," then in the next 15 or 30 seconds, I'm going to lay out a brief, quick foundation. And now I ask my key critical question and then move on from there. And that whole nonsense about asking about his credentials, yeah, I'll get to that 3 hours later. You know, I realize you're watching this because it showed up on your Facebook feed, or you're watching it on the replay because you're actually searching for this information and you have more questions. Well, let me tell you something. If your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I encourage you to do is pick up the phone and call me. I can answer your questions. You know, I answer questions like yours every single day, and, you know, I'd love to talk to you. Let me just put my phone number on here so you can call me. 516-487-8207, and you should see that right now. So if you have questions, I want you to reach out to me at 516-487-8207, or you can reach me by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day. Bye-bye, everybody.